The Citizenship Amendment Bill 2016 was introduced in Lok Sabha on July 19, 2016. The bill was subsequently referred to a joint parliamentary committee which is currently examining it. The bill amends the Citizenship Act of 1955 with regard to two kinds of persons. Firstly, illegal migrants, and secondly, overseas citizen of India cardholders. To begin with, how can Indian citizenship be acquired? Under the Citizenship Act, Indian citizenship may be acquired by a person on various grounds. These include on grounds of being born in the country, or being born to an Indian parent, or having resided in the country over a period of time. However, the Act prohibits illegal migrants from acquiring Indian citizenship. Now, who is an illegal migrant? An illegal migrant is a foreigner who either 1. Enters the country without valid travel documents like a passport, or 2. Enters the country with valid documents but stays beyond the permitted time period. Under the Foreigners Act 1946 and the Passport Entry into India Act of 1920, illegal migrants may also be imprisoned and deported. In September 2015 and July of 2016, the central government issued two notifications exempting illegal migrants belonging to Sikhs minority communities from Afghanistan, Bangladesh and Pakistan who had come into India on or before December 31st, 2014 from provisions of the Foreigners Act and Passport Entry into India Act. These six minority communities are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians. This implies that these groups of illegal migrants cannot be imprisoned or deported for not having valid papers. The Citizenship Amendment Bill seeks to grant further benefits to the same group of illegal migrants from the six minority communities and the three neighbouring countries. It proposes to make them eligible for citizenship. This implies that illegal migrants who are Muslims or persons belonging to other minority communities such as Jews or Baha'is will be ineligible for citizenship. The question here is whether this provision meets the standard of equality guaranteed under Article 14 of the Constitution because it provides differential treatment to illegal migrants depending upon the religion that they belong to. Article 14 guarantees equality to all citizens and foreigners. It requires that a law must only treat groups of people differently if there is a reasonable rationale for doing so. The statement of objects and reasons of the bill does not provide any such rationale. Therefore, the question remains whether the provision in the bill that differentiates between illegal migrants on the basis of their religion meets the Article 14 standard of equality protection or not. The bill is also making changes to provisions regarding Overseas Citizen of India cardholders or OCIs. OCIs are foreigners who are persons of Indian origin. For example, they may have been former Indian citizens or children of current Indian citizens. An OCI enjoys various benefits compared to other foreigners, such as the right to travel to India without a visa or work and study here. Under the Citizenship Act, the central government may cancel a person's OCI registration on various grounds. In case of cancellation, an OCI residing in India may be required to leave the country. The bill is adding another ground for cancelling OCI registration, that is, if the person violates any law in force in the country. The issue here is that this provision grants wide discretion to the central government. The central government may now cancel OCI registration for both major offences like murder and minor offences like parking in a no parking zone or jumping a red light. The question here is that should OCI registration be cancelled for minor violations given it may require an OCI residing in India to leave the country. For more information on the bill, please see our website www.prsindia.org.